As a reaction, quite understandably, the German population was rather angry with those who, in their opinion, were after all responsible for the miserable situation in Germany. As a matter of fact, these were the surviving Nazi leaders that were accused at Nuremberg. Thus, the German population was at the time of the trial rather supportive of the Nuremberg process, as polls show that 80% of the German population thought that the Nuremberg trials were fair and just. A mere 6% were critical and some 9% thought the judgments were too hard. Realistically speaking, however, the trials were not followed by a general public in Germany. With a total collapse of the infrastructure, ordinary men and women had neither time nor facilities to inform themselves about what happened in the courtroom. German journalists were accredited to the Nuremberg trial, but as one of them, Dr. Susanne von Paczynski, last year in Nuremberg at the ceremony remembering the opening of the trial, claimed the German journalists were treated rather poorly and were discriminated against. The only exception, by the way, and this I read in the Frankfurter Allgemeine Zeitung, one of the main leading German newspapers, daily newspapers, one of the exceptions to this was one Markus Wolf. Markus Wolf was a German offspring. He was a Soviet citizen at that time, a former Soviet citizen, and he reported, he was in his early 20s, he reported for the East German, for the Soviet-occupied zone, broadcasting, radio broadcasting. And he later actually became very famous. He's still alive. He later became very famous because he was a director of the GDR, the East German intelligence service, counterintelligence, that would sort of send the spies over to West Germany and the rest of the Western world. So this Markus Wolf, he was the only exception because he, when coming to Nuremberg, he showed his Soviet passport and he, as he claims, was accredited and allowed into Castle Stein, which was a place where the international press camp was. At that time, however, daily newspapers were not available, TV was unavailable, radio broadcasting was, as it were, the only reliable source of information. However, there was another medium that was quite interesting at that time, which reported intensively on the Nuremberg trial. This was the so-called Deutsche Wochenschau, weekly news reports as well. News were shown in theaters, in movie theaters, just before the main film started. This, by the way, was an invention of the PR machinery of the Nazis to report on the party rallies and other events in order to spread the Nazi ideologies over the land. Now, instead of some Sportpalast speech of Joseph Goebbels, the Wochenschau showed Robert Jackson's opening address to the INT in Nuremberg. Yet the supportive attitude toward the prosecution at Nuremberg did not last very long. A few years after the trial, we can observe a certain tendency to rather not think about one's own past and deny a responsible dealing with the Nazi regime. Probably, I might say, the denazification process itself had a rather negative impact on German attitude altogether. The German public at large, I assume, had the impression to be under a general suspicion of being Nazis and felt to be criminalized in its entirety. Thus, we can say, in the early 1950s, the polling situation was different. Now, about 30% thought the trials were unfair, 40% thought the judgments were too hard, and even 50% said the Allies dealt with the German war criminals in the wrong way. However, the results, as shocking as they may be at first hand, they have to be read with caution. The German historian Norbert Frey has noted that the American-led poll, which I just referred to, did not refer exclusively to the Nuremberg process, but to the entire dealing with Germany by the Allied powers. The sentiment of a collective guilt, by the way, was tried to be avoided by having a criminal prosecution at all. A trial against individuals is clearly directed against individual guilt and deflects from the notion of a collective guilt. In the words of Justice Robert Jackson in his opening address, we will also make clear that we have no purpose to incriminate the whole German people. This speech, the opening address, was very well received in Germany. One German citizen writes to Jackson on December 14 in 1945, and this is my own translation, so please forgive if this is not understandable to you. Obviously it was in German. In no way could the court in Nuremberg have better demonstrated its strict objectivity to the German people. Now our people can trust these men who have sinned so nefariously against the life of our people and the well-being of the entire world. They will find the sentence which they deserve in Nuremberg. The most common criticism was the word of a victor's justice, Sieger Justiz, as we say in German. Just as Hermann Göring is reported to have commented, the victor will always be the judge and the vanquished the accused. But again, Robert Jackson, either the victors must judge the vanquished, or we must leave the defeated to judge themselves. After the First World War, we learned the futility of the latter course. End of quote. Another criticism of the Nuremberg trial stretches to the question whether a military leader can be held responsible for political decisions. The defense of Nuremberg, and in particular Professor Hermann Jarreist, who was defense lawyer for the accused Alfred Jodl, acting general of the High Command of the German Wehrmacht, pleaded that a military leader pursues orders but is not responsible for a political decision to go to war in the first place. Defense counsel Dr. Latent, he was defending the German High Command of the Wehrmacht, quoted the speech of the British General Lord Montgomery of July 26 in 1946 in Portsmouth. I quote, "The army is the servant of the nation and stands above politics. The army is not one gathering of individuals, but one fighting weapon, formed by discipline and controlled by discipline." And still these days, ladies and gentlemen, it is very difficult indeed to speak about the crimes of the Wehrmacht, of the German army. When in 1995, only 10 years ago, the Hamburg Institute of Social Science sponsored a research into the crimes of the Wehrmacht. It was called the War of Destruction, 1941 to 44. A tremendous uproar arose in Germany. Many Germans felt offended as the myth of the high moral standard of the German army broke apart. Another criticism of the Nuremberg process is the fact that at Nuremberg, German victims were not made an issue. Again, Markus Wolf, commenting for the Berliner Rundfunk, stated after the judgment was handed down, and I quote, "The question arises now whether the German people, a German court, or several courts could participate in clearing the country of the most guilty persons and try the crimes committed against the German people. In many instances, this would without doubt be in the interest of justice, and at the same time, Germany could take responsibility for its own process of developing democracy." These phrases, by the way, were censured by the Soviet judge Nikishenko when he was asked to authorize the comments before they being broadcast. Nikishenko was referring to the special courts which had been established by the Allied authorities, and that were apparently, for him, enough. German courts were not necessary. The American officer responsible for the Berliner Rundfunk, however, allowed these sentences to be spoken, and later it was indeed referred to German courts to adjudicate in these cases. This little story tells us that the participation of the victims in a trial, according to my view, is obligatory. In state crimes, the participation of the suppressed people is obligatory. By this, the prosecution will contribute to healing the wounds and doing justice to all parties involved. I think that the poor reception of the German trial in Germany is also owed to the fact that Germany was not invited to participate actively in the prosecution. It was therefore conceived of as being something entirely foreign. The International Criminal Court, by the way, takes heed to this fact, and it integrates victims and peoples into its process, for example, by allowing ad hoc judges. And at the same time, however, I have to utter a warning. The later prosecution of Nazi crimes by German authorities has a rather poor record. We've just heard about that. The overall idea of German jurisprudence in this regard looks as if it were aiming at a biological solution, if we want. The biological solution to the problem of Nazi crimes. Bernhard Schlings writes that the German judiciary was struggling to sit through the problem. Aussitzen is a German term for them, to sit down and wait until the storm is over and act. This is an apt word to describe the judicial reactor. Therefore, I suggest that a supranational control, as the ICC would be, seems necessary to supervise the unbiased prosecution of war crimes on a national level. Let me come to my second point and quickly go through some defense problems. Justice Jackson conceded in his report to President Truman on October 7, 1946, I quote, "The London Agreement devised a workable procedure for the trial of crimes which reconciles the basic conflicts in Anglo-American, French, and Soviet procedures." End of quote. German procedures are not mentioned. In the following, he emphasizes that the Charter set up a few simple rules which assured all of the elements of fair and full hearing, including counsel for the defense. However, nowhere in his report, I could at least find it, maybe John can enlighten us in that, nowhere in his report he finds the German defense lawyers worth mentioning. In contrast, by the way, to the IMT's President Lord Lawrence, he repeatedly emphasized the noble work of the defense lawyers and promised to them any protection the IMT could offer against defamation and threats. The defense team consisted of a variety of individuals. Some were more experienced, like Otto Kranzbühler, a former judge at the Naval Court. Some were rather young, like Alfred Seidel, but nevertheless energetic. Some were former Nazis, some were relatively innocent. In the following, I want to stress three difficulties of the defense. First, infrastructural problems. Second, the general procedural order. And third, the violation, we have already heard about this today, the violation of the retroactivity principle. And put these into a modern context. First, to structural deficiencies. The defense lawyers suffered immensely from infrastructural problems. Life in Germany was hardened by the consequences of the war. Surviving was the primary aim. The IMT respected these circumstances and supported the defense lawyers with monetary aid. Every council received a grant of at first 2,000 Reichsmark and another 7,500 Reichsmark in 1946. However, the individual lawyer had to finance all the logistic and assistance on his own. Although considering the social circumstances in Germany, the ordinary payment at that time was some 38 Reichsmark a week. This was rather a lot of money. It was, however, not sufficient to operate properly for the defense. Against a, as it were, almighty prosecution team, the US team alone consisted of more than 200 lawyers, the defense team was rather helpless. Looking at modern international criminal law, we discover quite similar structural deficiencies. The Office of the Prosecutor, for example, at the ICTY, is well equipped with personnel and, by the way, has the power to force cooperation of any UN member state worldwide. In contrast, the Defense Council is a lonesome fighter. To avoid these inequities, the Special Court in Sierra Leone has established a defense office as a structural equivalent to the Office of the Prosecutor. Whether this is the right answer or not to this problem, we will see. But the problem, however, have been the same as in Nuremberg. Let me come to my second point, the procedural order. As a general requirement, any criminal trial needs to be fair. The question is whether a procedure which is totally foreign to the accused and the defense counsel at the same time can still be called fair. The London Charter doesn't bother much to take into account the German procedural tradition, as the earlier Jackson quote proves. Whitney Harris told me, one of the still surviving prosecutors of Nuremberg, told me last week that to refer the last word to the accused was meant to be a contribution to German criminal procedure. Well, yes, it is, but the structure of the trial, nevertheless, remains very much one of common law. And this Anglo-American procedure was foreign to the German lawyer. One could observe the relative reluctance of defense counsel to intervene actively in the proceedings. This doesn't surprise, as a criminal trial in Germany is conducted exclusively by the active judge who inquires the case. The prosecutor and defense counsel are merely present to plead and comment, but the main inquisitor is the presiding judge himself. The German defense lawyer is not used to collect and present evidence in court. So was the trial unfair towards the accused because of this? The German Federal Constitutional Court has held in its decision of 18th of July 2005, in which he declared the European arrest warrant void and unconstitutional, and I quote, "With its ban on expatriation and extradition, the fundamental rights enshrined in Article 16 of the Basic Law, our Constitution, guarantees the citizens special association to the legal system that is enshrined by them. It is commensurate with the citizen's relation to a free democratic polity that the citizen may, in principle, not be excluded from this association. The constitutional provision aims, according to the Germans, to these highest judges in Germany, aims at preventing a similar expatriation process as the Jewish population had to suffer after the Machtergreifung by Hitler, starting with the so-called Nuremberg racial laws of September 1935. This is taken from the reasoning of the Supreme Court of the German Federal Constitutional Court, in this case declaring the European arrest warrant unconstitutional. Whether or not it is actually a fair comparison in this regard to compare the European arrest warrant with the racial laws of Nuremberg, I'm not sure about this. But however, the question arises whether or not a complete foreign procedural system is, as such, unfair to an accused. But I want to not to go in further detail with that, just to throw this to you for further thoughts. My time is running out, so I'm cutting a bit short here. We can seriously see that many difficulties that we had that we can discover at the Nuremberg trial prevail and are still present at modern international criminal trials. It is always difficult to find a way, the small path between a speedy trial and a fair trial to the defendant. The Milosevic trial, for example, has proven that it is difficult to meet the small path. The middle path is certainly hard to find, and international criminal procedure is still struggling to find this narrow line. I want to have here another comment, which actually I was reminded this morning by Professor Maris, who was alluding to the fact, and I've never thought about this before, that the German accused were actually quite happy to play the game. They were sort of accepting that a trial as such was, as it were, a natural thing. Professor Friedlander had just said maybe they were better brought up than Saddam Hussein. And maybe this is actually true. Because also for me, I've never thought about this point, because it is a natural thing to have a trial after a crime occurred. And it is very well within the culture of the German people to have the trial, notwithstanding the fact, obviously, that during the Nazi period, the rule of law was hampered and was treated very badly. Nevertheless, in the German culture, and Sherry Basuni has stressed this point in the conference in St. Louis last weekend, stressed this point that it is very much part of the German culture to accept criminal trials as such. Let me come quickly to the ex post facto law problem. That was maybe the most important issue in this regard. The claim that the Nuremberg trial violated this principle pertains in particular to the question of a crime against peace. The other crimes, like war crimes and crimes against humanity, are in truth, at least according to German scholars, relatively unproblematic as concerns the principle of non-retroactivity. For the general public, however, the entire prosecution was a violation of this principle. And this notwithstanding Hans Kelsen's claim that the principle of non-retroactivity doesn't exist in international law at all. And the West German state put this principle at a very high and prominent place in its constitution. In Article 103, paragraph 2 of the Grundgesetz, the basic law of Germany, it says, and I quote, "Nobody shall be held liable for a crime that wasn't a crime at the time the act was committed." When Jackson observed in 19 54 that the German constitution embraces the achievement of Nuremberg. He is right in most of the cases, but he might have overlooked this provision. This was meant as an unequivocal statement against the Nuremberg trial. The European Convention on Human Rights, an extremely successful instrument in the promotion of the rule of law and the respect for human rights in Europe, and now even stretching far into the Eastern European context, and Turkey even, incorporated the provision against retroactive prosecution in Article 7. When it was drafted in 1950, the memory of Nuremberg was still vivid, so that in Article 7, paragraph 2, an exception was inserted for heinous atrocities which violate the conscience of humanity. The young West German democracy was cautious enough to implement a reservation to this prevention upon ratification of the convention. This was done despite the fact that Gustav Rakow, the pre-Nazi German Reich Minister of Justice, claimed in 1946 that highly unjust laws cannot justify criminal acts. Also, this reservation, ladies and gentlemen, is a clear and unambiguous sign of mistrust against Nuremberg. Now, what about Germany's attitude to Nuremberg today? Somehow, Germany's view has changed. Germany's view has changed in this. Ever since the achievement of German unity in the 1990s, Germany has discovered international criminal law to being a realistic way to contribute to peace and security in the world. Maybe it also hopes to justify the Nuremberg trial by supporting the establishing and the work of an ICC, now ex post, as it were. And yet there are still reservations to be made. I was very disappointed when not long ago I opened chapter 1 of a brand new commentary on the German Criminal Code. The commentator, who by the way is the Vice President of the Federal Constitutional Court, Professor Hasseler, writes that the Allied power had reintroduced the non-retroactivity principle, which is correct, and adds in parenthesis, I quote, however, the Allies were less strict with observing the principle themselves, end of quote. Ladies and gentlemen, this is the only mention of the Nuremberg trials in this introductory chapter to this big commentary on German criminal law. And I think it's particularly sad, laconic, and 60 years after the trial at Nuremberg, if I may say, a pathetic comment. As a matter of fact, the German officials took a rather different view. You can see, ladies and gentlemen, I don't know how many of you are aware of that, but the courtroom 600, the room in which the Nuremberg trial took place, is still an active courtroom in the Palace of Justice at Nuremberg. The city of Nuremberg has decided to continue to use this room as a courtroom, yet, now 60 years after Nuremberg, to establish a documentation center and to make this room more approachable to the general public. So whenever you come to Nuremberg, maybe 1 or 2 years from now, at the moment we're at the stage of fundraising, applied for funding to the federal government, and to the government of the Bavarian state, you may find this in an adequate environment that you can actually access the room and get information about how it took place. And I can only advise you to go and come and visit Nuremberg and the courtroom because it is a tremendous experience when you actually enter the room and you feel the room looks exactly the same. You recognize it at once and you feel a little bit of the spirit of Jackson and the atrocities that were actually convicted in this room present. So this is the city of Nuremberg who does a lot to sort of maintain the legacy of Nuremberg. And as well, the German government took a different view to the Hassener approach, which I just quoted in this comment. The reservation made to Article 7, paragraph 2 of the European Convention on Human Rights was withdrawn in the year of 2001. I might say rather silently. I only realized this last year, 4 years later, that they had withdrawn the reservation that they did. By this, and this is the end of my presentation, and I want to quote Klaus Kress, who's Professor of International Criminal Law at the University of Cologne. He said last year in Nuremberg at a conference memorizing the beginning of the trial, he stated, Germany has formally joined the international community in its recognition that the evolution of international criminal law is marked by certain points of crystallization which do not meet the most stringent standards of the principle of non-retroactivity. At the same time, the withdrawal of this reservation signals that Germany has made its peace with no one. Thank you very much for your attention.